The man who wants to run the country for the next 4 years cannot run a business in New York State for the next 3. That is part of Judge Arthur Engoron's civil fraud ruling against Donald Trump. Engoron also fined the Republican frontrunner with more than $350 million. With prejudgment interest, Trump already owes more than $450 million. A spokesperson for the Trump Organization called the ruling a, quote, gross miscarriage of justice. In his decision, Engoron said, quote, defendants' refusal to admit error, indeed to continue it, according to Independent Monitor, constrains this court to conclude that they will engage in it going forward unless judicially restrained. Joining us now in New York with me, MSNBC legal correspondent Lisa Rubin, also with us, investigative reporter for the New York Times in Washington, D.C., David Fahrenthold.
Hi, Lisa. Since we've been hanging out so much this week, I want to start with you because, this is a big number. I don't care how you cut it, how you dress it up or try to dress it down. It's a big number for him. Walk us through how the judge came to this number, what it means for Donald Trump, and what his potential impact is on his business opportunities in New York.
So, Michael, the number that the judge arrived at here largely comports with the relief that the Attorney General asked for. And it wasn't that they invented a number out of whole cloth. It corresponds to what they say were ill-gotten gains obtained by the Trump Organization and the individual defendants, namely Donald Trump, from several different buckets. One of them is the saved interest that they got in negotiating loans through their fraud. Basically, the argument is that they got loans at much lower interest rates than they should have ordinarily gotten, because if people had understood the full totality of Donald Trump's financial picture, they never would have loaned to them at these rates. Some of the other money comes from proceeds that Donald Trump made from sales. He sold the lease, for example, to the old post office in Washington, D.C. He also earlier last year, in June of 2023, transferred a lease to the Bally's Corporation, mostly known for gaming, at a golf course here in the Bronx operated by New York City. There are some other components here to the overall number, but those 3 buckets compose the majority of the award that Judge Arthur Engoron made yesterday. And of course, as we learned later in the afternoon, you add another $100 million, give or take, to that for prejudgment interest based on when these sales were made or when that interest was saved. And all told, we're really now looking at an award of over $450 million. And that's before you get to post-judgment interest too, Michael.
That's a lot of money.
It's a lot of money.
It's a lot of money. David, I think you have covered Donald Trump in a way, when he was president, in a way that I think few others have definitely done. Your reporting was always spot on. And I am wondering, one, what do we know about Donald Trump's ability to pay this fine? Also, given the other fines that are literally racking up against him from the E. Jean Carroll case is what I'm thinking of. And then secondly, just what has the reaction been in their orbit about this ruling?
Well, the Trump Organization is still kind of a black box to us. We know a little bit more about it than we used to. And what we know is that he has, at last report, about $600 million of liquid assets, of cash, things he can turn over right now. So between this 450 and the E. Jean Carroll verdict of more than 80 million, we're talking about a big chunk of that cash being eaten up. Now, that doesn't mean Donald Trump's going to go bankrupt. He still owns a lot of real estate that he could sell and turn into cash. And he's also making a lot of money from political activities, people just paying him for speeches. And he has this weird, if you guys remember, Truth Social, that that attempt to create a public company is moving forward. And that could create billions of dollars of assets for him. So he's not going to go broke. But this could seriously decimate the Trump Organization as we know it. It's not a big company, and now it's losing a lot of money and basically all of its leaders.
The fact, Lisa, that they testified and their credibility was called into question, what does that mean legally for him now and moving forward?
Well, I think it should cause Donald Trump's attorneys to really consider the utility of his testimony in upcoming trials. You'll remember that after he testified in this case, and he was forced to testify by the Attorney General, he actually didn't testify in his own defense when it came time for his lawyers to present his case. He testified very, very briefly in the E. Jean Carroll trial, but not by choice. Really because Judge Lou Kaplan didn't want to listen to him pontificate. So I think first and foremost, it presents folks like Todd Blanche and Susan Nicholas, who represent him in this upcoming criminal trial with a real dilemma. This is a judge who said that Donald Trump's own testimony was not credible. It was highly suspect to him. He also said the same thing about Alan Weisselberg. And that's important because Alan Weisselberg and Michael Cohen are sort of the other two sides of what I'd call the Trump Holy Trinity when it comes to who is in the room when Donald Trump gives his indirect mob boss-like instructions about what he wants to have happen. That was no less true in this case than it will be in the upcoming Manhattan DA's criminal trial, where the allegations in the indictment were that Trump completely understood what the arrangement was going to be. Michael Cohen was going to pay Stormy Daniels, and then he and Weisselberg and Trump came up with this scheme for repayment that disguised those repayments as if they were invoices for legal services. So I think it should cause the Trump world some serious pause, and yet a client always has the right to direct their own defense. And increasingly, you see Donald Trump surrounded by lawyers who are unwilling to say no to him. I was stunned earlier this week at a hearing in the criminal trial when Todd Blanche, who I will confess, I know from practice, at the very end of the conference, the judge asked him, was there anything else, Mr. Blanche, that you'd like to add? And he bowed his head and conferred with Trump, lifted it up, and then made the same, this is political interference, this is election interference argument that Trump makes all the time in his own behalf. But he was insistent that a lawyer make it for him.
Michael, that is one hell of a holy trinity, to borrow Lisa Rubin's words.
Yes, just as we're beginning Lent, this is what we start with. It really is. And David, I want to ask you a little bit about the sort of the aspects of this case that are kind of glossed over, people don't really get into, in terms of how Judge Engoron really kind of came down to this ruling, but more importantly, how the Trump team is responding to it. We have, for example, the reaction in a statement from the organization saying today's ruling is a gross miscarriage of justice. Every member of the New York business community, no matter the industry, should be gravely concerned with this gross overreach and brazen attempt by the Attorney General to exert limitless power where no private or public harm has been established. It's the private versus public harm argument that I think Trump's team is going to be leaning into, that there was no harm, no foul here. But that clearly landed on deaf ears with the judge. How do you see Trump playing this narratively for the public, to make it seem like he's yet again a victim, and trying to find some comfort with other members of the New York business community who may, quote, find themselves similarly situated?
I do think that has been his argument to the public and to the judge. It just didn't work with the judge. That, you know, the lenders were still happy to lend to me. They still made money. I made all my loan payments, ignoring what Lisa said earlier, that this is about truth. Like, you can't just lie to your lenders, even if in the end that, you know, you paid them and you got a loan. You know, in New York and everywhere else, you know, there's an assumption of truthfulness. And if your lenders ask you for your assets and you lie to them on purpose to try to get a better deal, that's against the rules. So I think Trump is trying to sort of get rid of those differences in a way that the public will understand. But even then, I think he's, you know, the old adage that if you're explaining, you're losing. I think what his argument is more complicated than a judge just assessed him a $450 million penalty for fraud.
You know, I mean, David, that point is actually, it's just so important. I want to pull directly from Judge Engoron's ruling in case folks are just waking up this morning and haven't had a chance to hear what he said. But he writes, Donald Trump is not Bernard Madoff, yet defendants are incapable of admitting the error of their ways. Instead, they adopt a see no evil, hear no evil, speak no evil posture that the evidence belies. And after this ruling came out, or pardon me, this decision from the judge came out, you had AG Letitia James, who is the person who brought this suit, who now, again, has found some justice for folks. She spoke about why she felt this was very important. I want to play that for folks.
Today, justice has been served. Today, we prove that no one is above the law. No matter how rich, powerful, or politically connected you are, everyone must play by the same rules. Donald Trump may have authored the art of the deal, but he perfected the art of the steal. This long-running fraud was intentional, egregious, illegal, and he did all of this with the help of the other defendants, his 2 adult sons and senior executives at the Trump Organization.
It's Black History Month. Of course, Tish James is going to give her statement. Look, Donald Trump does believe he's above the law. And every single moment that he has met with even just a little bit of justice, I think that it just further underscores our systems that he has tried through various ways, whether it's our political system, our legal system, to dismantle. And today, yesterday, Judge Engoron and the state of New York, they stood up to Donald Trump.
I think that's an important part of this conversation, Lisa, because what Letitia James did was something that no one thought could really be done, to be honest. Everyone thought that this was just, barking in the wind, making a lot of noise, and that it was all politics. There was substantive criminal activity going on in hiding resources, inflating resources and assets, and it's come home for him. You wrote a great piece for MSNBC.com on Friday before the ruling came out, talking a little bit about why Trump just can't up and move out of New York. Why, and sort of really contextualizing what is real for this man right now. Talk to us a little bit about your thinking in your piece on Trump's truth in his businesses in New York.
Well, Michael, I wrote that piece in large part because it was a conversation that I had with people outside the worlds of journalism and law, asking me, well, wait a second, if they're saying he can't do business in New York, why wouldn't you just take your assets and your bank accounts and move them to a more hospitable state like Florida, where he lives? Trump has been under a preliminary injunction, which is just a fancy way of saying an order that restrains him, since 2022 because of this investigation and because of this case. About 2 months after Letitia James first filed her complaint, she asked for that relief, saying that she had enough evidence to show, even at that early stage, that he should be prevented from doing a number of things with his assets. And those things include, after the appointment of the independent monitor, he cannot wholesale transfer, sale, any of his significant assets without notice to the independent monitor, and nor can he restructure or refinance his businesses either. That's important because, as David noted, if you're a person whose liquidity is thought to bump up right against the two liability determinations that you already have, that in the E. Jean Carroll cases and here, you would think that one solution is to just borrow money. And in fact, Trump has done that before. In order to satisfy a judgment in the Trump University case, he borrowed money from Ladder Capital, which is an institution with which Alan Weisselberg's son, Jack, is affiliated. But he can't do that here. And the reason is because this order, in addition to the preliminary injunction saying you can't refinance, you can't restructure without advance notice, this order goes even further. It says you can't borrow money from a New York registered or chartered bank, period, for what I believe is at least a 3-year period of time. That means in order to satisfy these judgments, Donald Trump has to, I think, rely on his own asset base. And yet he has an independent monitor who's going to be on top of him every step of the way, as well as a new independent director of compliance who's going to be scouring the books and making sure that what happens at the Trump Organization from now on is on the up and up, to use a legal term.